Right out of the gate, this isn't a clean custody dispute. It's a layered legal mess shaped by overlapping courts and strategic timing. The mother's side frames the father as unstable, disconnected, and dangerous, stacking incidents like living in the woods and alleged behavioral issues to build a narrative of risk. That's not random detail, that's positioning.
Is that one of the issues that we're dealing with today?
It would be, Judge, but there's also a juvenile court case that's happened since then, and jurisdiction was relinquished back to this court. That's why Mr. Parks is here. He was the guardian ad litem for the children. That was in April through December of 2024.
Right. And so what are we fighting over today?
Well, if I just may briefly, Judge, the juvenile court case dealt with some issues that were going on at Dad's home. He was married to his wife, Lacey, his former wife, Lacey, at that time. She's actually here. They divorced. There was an incident that happened with Levi. As a result of that, my client filed an emergency custody petition. That matter was heard and the children were removed from the father for a period of time. Through in December, he was granted some sort of limited visitation that wasn't every other weekend. I had that final order and then relinquished custody back to this court. Then he started having issues in his marriage. He divorced his wife. There were some concerning behavioral issues that happened with Dad. He was actually living out in the woods for a period of time. There were some things with animals that happened. He has not seen these children since December of 2024. He stopped paying child support. My client had to move to Michigan. I filed a notice of relocation with the court. He stopped paying child support. So there was an arrearage in child support, and he's not seen these children since December of 2024. These children are now 14, almost 15, and 12, almost 13 are both here and do not want to have contact with their father. They're afraid of their father. The ex-wife is here to talk about some substance abuse issues and some concerning behavioral issues. And we would ask that there is no contact with the father.
Space.
It's my client's position that mother has continuously and systematically used the system in Montgomery County and in Stewart County to limit my client's contact with these minor children to get what she wants, which is ultimately to move to Michigan to be with her boyfriend. And that's what she's done. She's accomplished that. And quite honestly, them now coming and saying they've had no contact with their father since December of 2024, they've been coached to say these things. It's my client's position. He needs to have a way back to continue to get contact with them, to be able to foster a relationship with them. Mother clearly doesn't want it. I think that the next step would probably be for mother to isolate father even further from these children so that her husband, when she marries, can then adopt the children and completely cut father out of the situation. Yes, he went through some issues. We'll address those issues in the testimony that he's going to provide today. But there's no reason that this order of protection should stay in effect. The allegations that were raised, I believe the order of protection was filed in early 2025. That's what's in place right now, is that order of protection.
The order of protection that was issued by Judge Brigham expired on March the 3rd of 2026. So there is no pending order of protection.
There was another one that it looks like was filed by mother. Was another one that was filed March 4th of 2025.
And was there a temporary, I don't have a copy of that. Was that in general session?
Maybe. Yep, and it looks like it may be. I don't believe there's ever been a hearing on this.
Right, and this one is based upon, at least partially upon, the allegations that were involved in his prior relationship, prior marriage, in which there were animals involved,
Specifically, it says in there that there's no known harm to the children.
Right.
So again, we believe that this is mother methodically laying cases out in front of multiple courts to limit father's time. And that's what she's continuing to do. All we're looking for is a way back for these children and father to foster a relationship.
All right.
And if I may, I can pass forward the last order from the juvenile court, which set forth that father it was in April of 2025. Father had not visited with the children since December of 2024. And that's when the court relinquished jurisdiction back to this court. I think that would be helpful for them.
All right, we'll let you go ahead and mark that as Exhibit 1 to this hearing. So that we're all clear, there is a pending appeal on the order of protection that was issued by Judge Brigham in March of 2025. That has not yet been heard by this court or any other court. And therefore, we'll have a hearing on that order of protection. Then the other issue is the request for relocation. There is no pending petition to modify the parenting plan, if I recall correctly. Is there a?
Yes, there is. It was transferred from Montgomery County. It was filed in Montgomery County and they transferred it to. I have the order transferring it to Stewart.
Well, I've seen the order transfer. That was.
Here's
No.
the petition that was filed back in November of 2024, Judge.
Okay. Well, maybe what I missed. Therefore, I do not have in our file a petition to modify the parenting plan that was originally adopted. And I cannot rule on matters that are not properly before me because my jurisdiction extends to what's in our court file, not what's in another county's file. So as a result of that, I necessarily have to continue your hearing. I don't really want to do that, but I don't really have any choice. And as a result of that, the next available date that I have, and I've gone over it with your lawyers, is my next regular chancery day, which is August 4th. Now, that's a long way away. In my opinion, in this case, there needs to be the reappointment of the guardian ad litem that was appointed in juvenile court. So I'm going to reappoint Mr. Charles Parks, who was here this morning, to be the guardian ad litem in this court as well. In addition to that,
the judge reframes the entire case. This is no longer about past behavior alone, it's about legal thresholds. Terminating a father's rights isn't just difficult, it's one of the highest standards in law. By emphasizing that, the judge quietly dismantles the idea of no contact as an easy solution.
You've got teenage daughters, and while they are expressing a preference regarding that, it is not a simple thing for this court to simply say that a father can no longer see his children, period. Although there may be issues that have arisen in the past, there are instances where there have been abuse of children, and we still are required to allow the children to have some sort of therapeutic visitation with the minor, with them. Ms. Wyman, if you'll stop what you're doing so you can listen to what I'm saying. It's very important for two things. Number one, the children need to understand that the law says Mr. Blue has a right as a father to see his children. Termination of the parental rights is one of the most important and significant things that can occur in the courtroom. We had that this morning, and it requires a finding by clear and convincing evidence, which is the highest standard for evidence, that it's in the best interest of the minor children to terminate the father's rights. So under these circumstances, there are issues clearly, and that he's not seen the children, there are allegations about parental alienation and so forth. To identify what the issues are between you and your daughters and to try to protect their best interest as well as balancing that against your right as a father, I'm going to order that these children be, that there begins some sort of therapeutic counseling between you and your daughters and a therapist. Dr. Charles Ehrig, I think both of your lawyers are Ehrig, maybe the right way to pronounce it. He's an expert witness in many cases in this court. Both of your lawyers are familiar with him. If the girls live in Michigan, then there should be an ability to do a telehealth type of a situation where they can do that by Zoom if necessary, and that will allow him to make an assessment. But in order for me to make an informed decision regarding what's in the best interest of your daughters, I need some expert testimony regarding what is in their best interest from a person who deals with this on a regular basis. Dr. Ehrig's responsibility will be to talk with the children, determine what is in their best interest, and then make that recommendation to this court. So as a result of that, this court is of the opinion that there should be an order down ordering that the therapeutic visitation or therapeutic counseling, it will not be visitation, but therapeutic counseling with Dr. Ehrig and the parents can all be arranged. Now, what that necessarily means is that your daughters are going to be involved in talking to Dr. Ehrig. So as a result of that, it is a difficult balance you strike not to talk about this case with the children. The main thing we don't want to do is to give any ammunition to Mr. Blue that says that the children are being influenced. And there are subtle ways to influence children, but I think under these circumstances, we just need to have a rule that the children will not be involved in any discussions about this case, other than the fact that this is what the court has ordered regarding Dr. Ehrig's counseling, and that is a mandatory thing that they're going to have to enroll in. But beyond that, talking to the kids about what their preferences are and so forth, then we'll get to that eventually. And we have a guardian ad litem. Let the guardian ad litem speak for the children and let them communicate with him so that he's fully informed as to what their position is. That's his whole purpose, is to determine what's in the best interest of the children. But putting the children in the middle and asking them to pick or choose or trying to influence them just makes things more difficult for them, in my opinion. So we're going to try to protect them the best we can from having to be exposed to that. Under these circumstances, I'm sorry I cannot go forward with it today, but I do believe that this is in the best interest of your children to do that. So, anything else before we adjourn?
With Dr. Ehrig, I've also had a lot of experience with his reports. He does like non-self-reporting type situations where he speaks to other individuals, such as both parents and other individuals, to get a background with regard. He does Rule 35 evaluations with regard to mental health evaluations. And we think that's critical in this particular case, that as part of this, we look into Mr. Blue's mental health.
There's been no Rule 35 request that's been filed, so you would have to file a motion for a Rule 35 evaluation for me to make a determination. Again, I can't rule on something that's not before me, but I understand the basis for your saying that, and I understand the reasons why you would suggest that. And clearly, based on the orders of protection that I've reviewed and the information that was supplied, there is an issue. So, if Mr. Blue is serious about seeing his children, he might want to address some of those situations, either with Dr. Ehrig or someone else, so that there can be some evidence that as to what he's dealt with. There is clearly a pattern in teenage boys, for example, who abuse animals, that can lead to more serious crimes, including sexual or violent tendencies. A lot of serial killers started out killing animals and abusing animals as a result of that. So let's get that taken care of, but I do not have an order. I do not have a motion for Rule 35 evaluation, which would be court ordered. But Mr. Blue, if he's willing to try to help the court in making a determination regarding his children, obviously it would be in his best interest to try to address that issue. All right, then this matter will be reset for August the 4th. And Ms. Turner, you're the moving party. I'm going to ask you to draw an order that reflects what I've been.
I will do that, Judge. Thank you.
Yes, ma'am.
The children are here today. Father has not seen them since December of 24. He would just like the opportunity to say hello to them, to check them out.
The daughters, it's a daughter and son. The daughter is crying. No, she does not want to talk to him today.
If the son is here, any contact he can have with these children,
Contact Mr. Parks, who is now the guardian ad litem. Tell him what the situation is, see if he can talk with the children to determine whether or not they're willing to do it. Forcing teenage kids who don't want to do something to do it may be counterproductive for Mr. Blue. But they need to know that he would like to see them and like to have an opportunity to talk with them. So I think that Mr. Parks, who's here in town, could come back over and talk to the kids, and then why don't, before you leave, since you were going to be here most of the morning anyway, why don't, before you leave, let's see if you can't get something worked out. Maybe Mr. Blue can just say hello to them if anything, but I think they do need to know he wants to see them. It is a difficult thing for a child to process, in this court's opinion, that when they haven't seen someone, one of their parents for a long time, they don't necessarily understand why that has happened. And oftentimes they will think it's because that parent does not care about them. So letting them know that he does care enough to wants to see them would be, in my opinion, something that would be beneficial to the children. Whether they then say they want to see him or not, at least let them know that he wants to see them.
The final stretch exposes the underlying concern that's been building quietly: mental stability. The discussion around animal abuse isn't random. It's a red flag with long-term implications. The judge doesn't order a psychological evaluation, but the message is unmistakable. If the father wants access, he needs to address these concerns proactively. That's a test of seriousness. Then comes the emotional closing moment, the request for simple contact. The judge refuses to force interaction, recognizing that pressure could damage the relationship further, but at the same time, he emphasizes something critical. The children need to know the father still wants them. That's not legal, it's psychological groundwork. The case ends unresolved, but the direction is clear: prove stability, rebuild trust, and come back with evidence, not arguments.